Okay, it looks like we've hit kind of critical mass here, so we're going to go ahead and get started. We do have a lot to go over in this presentation, so we're going to go fairly quick. Do remember that these webinars are posted in full on our website, and so you can access those and the materials there as well if you need to reflect back on anything that we've discussed today. My name is Emily Tulloch. I'm here with my colleague Jared Costanzo, and we are going to be talking today about the education law legislative update that follows this most recent legislative session. I will note that what we're going to be talking about today are just, at this point, bills that have passed both houses. We are still waiting for signature on these bills from the governor. As of yesterday afternoon, none of these have been signed yet. And then at the end, we're going to talk about three of the actual public acts that have been signed into law that you need to be thinking about this summer because that's when they go into effect. So without further ado, let's start with those bills passed in the recent legislative session related to labor and employment. So this bill, again, has passed both houses. This is Senate Bill 2914, and this talks about notice to remedy. So I know this made the rounds with a lot of school districts. I know there were a lot of advocacy organizations as well that provided some input with respect to this bill. It did pass through both houses, and it is veto proof. So I do expect to see this one be signed by the governor in relatively short order, and we're keeping an eye on that for when that goes into effect. But really what happens here is what's the same as before is, when we're dismissing a tenured teacher for conduct that is remediable, that teacher has to be issued a notice to remedy, which requires that the teacher get a reasonable warning in writing identifying the conduct that may result in dismissal if not remedied. That remains the same, right? But what this new bill requires is that the notice to remedy specify the nature of the alleged misconduct that needs to be remedied. I think that you're probably already doing that, but it does codify that requirement. It allows the teacher an opportunity to respond to the findings in the notice to remedy, either in writing or in person before the board prior to the board's vote to approve that notice to remedy. And then if the teacher disagrees with the board's action, the teacher can then take that notice to remedy to binding arbitration. This is a big shift in how we've been, issuing notices to remedy and moving through that tenure teacher dismissal process. It really allows the teacher to file for arbitration in accordance with the procedures that you have set forth in your CBA, or if there's no procedures in your CBA, it aligned with the procedures from the FMCS or the AAA. The rules of the FMCS or the AAA govern those proceedings, and those are two of the more national arbitration associations. And the arbitrator has the power to render a decision on the notice to remedy, which is final and binding on both parties. Again, this is really a lot of oversight from a third party coming in and being able to make a decision on what the district has set forth in the notice to remedy. I think there's going to be some difficult decisions when we're thinking about a teacher's conduct that may be on the line of remediable or not. We might be having some conversations about whether it's worthwhile to move forward with this process or the dismissal process. And I think that there's going to have to be some discussions with council about that. We are going to be having a webinar focused specifically on just this notice to remedy legislation coming up in a couple months here. And so please be on the lookout for that because we'll be able to kind of dive into more of what this means for folks once it's passed. I do see a question about the cost for the arbitrator and whether that would fall on the employer. So this bill requires that the arbitrator, I'm sorry, that both parties are required to pay half of the arbitration cost. So it does require a split. That may be a deterrent to some folks, but likely not all. So yeah. Okay, let's move on to the next bill related to employee mental health. So this is House Bill 4862. It requires school boards to develop by January 1st, 2028, a procedure for employee mental health in the workplace. This establishes requirements for what that procedure needs to contain, including adding resources to your employee handbook if you have one, or other readily accessible format to employees related to mental health resources. Then there's Senate Bill 2761. So this passed both houses and requires the in-service training programs for teachers, administrators, and school support personnel to also include training on accommodations for students. And that includes the ADA and the school environment and service animals. This one I'm noting does also apply to our charter school folks. So keep that in mind as you're working through some of your policies in advance of, once this is passed, when you're working through some of your policies and training procedures. Next, we have Senate Bill 2773. So this amends the requirements for issuing paraprofessional educator endorsements. So it allows for a paraprofessional educator endorsement on an educator license with stipulations to be issued to an applicant that is at least 18, and that will be using the license exclusively for pre-K through 8th grade. Until they are 19 years old. It also allows the issuance to an applicant who is 19 and otherwise meets those requirements for a paraprofessional educator endorsement. And it requires applicants for the endorsement to pass a paraprofessional competency test, hold an associate's degree, or be issued short-term paraprofessional approval by ISB, and be employed as a paraprofessional each year that short-term approval is valid, and meeting the competencies as determined by the school district. Next up, we have AI and teacher evaluations. So this one passed both houses and prohibits teacher evaluators from using AI to assign numerical scores or any qualitative ratings for any component of an evaluation or evaluation task that requires professional judgment. Evaluators are allowed to use an AI tool for what the Act calls administrative tasks, but the evaluator has to disclose the name and specific purpose of the tool used to the teacher being evaluated. The Act does also create a task joint committee to determine how AI tools can be used for those administrative tasks. So I expect to see some more guidance coming out about this because the bill itself is a little bit vague in, when we can use and how we can use AI for those administrative tasks related to teacher evaluations. This is not only limited to the evaluator, it also prohibits teachers who are being evaluated from generating evidence of their professional practice using AI in order to be evaluated. Again, that teacher can also use AI tools for administrative tasks, and I'm hoping as long as they disclose that information about the task, the name and purpose of the tool used to the evaluator. And again, I'm hoping we get some more information on that coming up soon here. And last in our labor and employment section, we have Senate Bill 2913, also about teacher evaluations. And this amends the school code regarding teacher evaluation plans and requires, starting June 1st, 2026, so the start of this month if it's passed, removal of the student growth component of teacher evaluation plans if the district and union can't come to an agreement about whether to incorporate that student growth component. and if there's no language in your CBA that requires that student growth component by reference. So really, if your CBA doesn't have anything about a student growth component and your district and union can't come to an agreement about whether they want to incorporate it, we just have removed that student growth component from the evaluation altogether. Again, this has not been passed yet, so I know I talked about a June 1st, 2026 effective date, but since it hasn't been passed, that has not gone into effect yet. I would anticipate seeing a relatively quick turnaround on the effective date for this one, though, if it is signed by the governor. And I'm going to turn it over to Jared to talk about our bills passed related to student issues.
Thank you, Emily. So yeah, now we're going to dive into some recent legislation that was passed by both the House and the Senate related to students, starting with House Bill 4581, transition planning. If we can go to the next slide, Emily, that deals with transition planning. It says by January 1, 2027, it requires school districts to provide informational materials on the Work Incentives Planning and Assistance Program to students and parents or guardians at the initial transition planning meeting during a special education student's final year in high school. The process of obtaining and disseminating the informational materials is to be determined by the school district in collaboration with the work incentives and planning assistance program serving the area. That program is federally funded through the U.S. Social Security Administration and is designed to assist people with disabilities to transition to financial independence. It serves people who are at least 14 years old, receives federal supplementary Social Security, security income or Social Security disability income benefits based on disability, and are either working, have an offer of employment, or are seeking employment. The next piece of legislation that passed both the House and the Senate pertains to color vision deficient literacy. It provides that starting with the 2027-2028 school year, color discrimination tests must be performed as part of the vision screening services that are provided for students in kindergarten, second, and eighth grade. So that's something to be aware of. But the law also requires the Illinois State Board of Education to provide public resources that are intended to support school districts and teachers that provide literacy to color vision deficient learners. Another piece of legislation that was recently passed is Senate Bill 3361 regarding religious hairstyles. The legislation prohibits schools from implementing dress code policies that would prohibit religious hairstyles, hair-related religious practices, or facial hair. Now, the legislation also specifically provides a definition of religious hairstyles, hair-related religious practices, or facial hair, and that's defined as hair length, hair arrangement, head hair, or facial hair maintained, worn, or displayed in accordance with a student's sincerely held religious beliefs, observance, or practice. And that includes, but is not limited to, uncut hair, side locks, beards, mustaches, or other facial hair. It's important to note here, though, that schools may still require that hair or even facial hair be secured, controlled, or covered during specific activities if it's necessary for the health and safety of the student or others and applied in a least restrictive manner. And it does not require cutting, shaving, or permanent alteration to the hair. Now, ISB will also be issuing guidance regarding religious hairstyles, hair-related religious practices, or facial hair. The legislation doesn't identify a date by which that guidance needs to be issued, but we'll definitely keep a lookout for that guidance. That should be forthcoming, hopefully soon. And last, related to students, is Senate Bill 3774. regarding administrative withdrawal of students. This prohibits schools from administratively withdrawing truant students. It requires at least 3 documented attempts to notify a student's parent or guardian of an intent to administratively withdraw a student. And a truant minor may not be administratively withdrawn for non-attendance unless they have accrued 15 consecutive days of absences without valid cause, and the student cannot be located by the school district, or the school district has located the student but cannot, after exhausting all available supportive services, compel that student to return to school. Again, this is passed by both houses, both the House and the Senate, but has not been signed by the governor. So we'll be keeping an eye out for when that becomes signed by the governor. That's it for students. So I'm going to hand this back over to Emily to discuss legislation related to curriculum and policy.
Awesome. Thank you, Jared. So let's talk about some of those curriculum and policy related bills that have passed. So first, we're going to start with House Bill 4788, which requires CPR training manuals starting the 2029-2030 school year to include the use of both breasted and non-breasted mannequins. And so you can still use those current mannequins that you have, and a breastplate may be used or some sort of chest cover may be used on those mannequins in order to comply. And then opportunities have to be provided for students to participate with both breasted and non-breasted mannequins. We also have House Bill 5552, which is really one of ISB's kind of annual cleanup bills. It makes a lot of changes regarding, annual statement of affairs, educators trained in other states or countries, and terminology related to epinephrine delivery systems, among other, minimal or kind of cleanup changes to language in some of the bills, or in some of the provisions of the school code, excuse me. One I wanted to point out specifically was that it does change the terminology in the school code to related to foreign language instruction to the phrases language other than English or world language. So that requires the changes in the terminology for some of your currently termed foreign language courses. So you might want to think about that for upcoming curriculum changes, possibly using world language or language other than English as opposed to foreign language. Then we're going to get to the cell phone ban. I know we were with some friends at EdRed a couple weeks ago talking about this. I asked folks in the room, who's excited about this, right? I really just wanted to see a reaction from some of our school folks, and I think almost everybody raised their hand. Some folks talked about how they're already doing this in some form or another. But SB 2427 passed both houses at the end of May. And it states that, before the beginning of the 27-28 school year, each school board must adopt and implement a wireless communication device policy that at a minimum prohibits students from using that device during school time unless otherwise permitted by the act. And we'll talk about that in a minute. The policy also has to incorporate guidance for device storage in the school building during school time. The policy needs to state the importance of the uniform enforcement of the policy in each school and the handling of that implementation in a trauma-informed and developmentally appropriate manner. And lastly, the policy has to include options for when parents or guardians are unable to come to the school to pick up the device, if that's one of the consequences for failure to abide by the policy. This, I know I have cell phone ban here in the title. This is broader and it does encompass things like smartwatches, personal tablets, or other devices under the kind of wireless communication umbrella. I've been saying cell phone just because I think that's kind of the buzz term for it, but do know that it includes more than just cell phones. It does define school time when wireless communication devices are prohibited as the regular school day from arrival time to dismissal time, and that includes instructional time, recess, lunch, and passing periods. Um, it does not include or prohibit wireless communication devices, before school activities or after school activities, or where a student's presence at an off-campus learning opportunity is occurring. So like a field trip, for example. This one also applies to our charter school friends. Um, this policy cannot prohibit a student from using their device during school time if a licensed physician, PA, or nurse practitioner determines that the possession or use of the device for the management of the student's is necessary for management of the student's health, and the student is using that device as prescribed. So we might think about, for example, a student who has diabetes and uses a Dexcom device, and there's an app on their phone or watch that reads blood sugar levels throughout the day. That might be an instance where we would see a permissible use of a wireless communication device that would not be in violation of this act or a policy. Students can also use those wireless communication devices to fulfill an IEP, a Section 504 plan, a medical order, or other written accommodation plan. If school personnel determine on a case-by-case basis that the device is necessary for a student caregiver who is routinely responsible for the care and well-being of a family member, students can also use that device in those cases, and then as required by state or federal law. The last point I want to make, or one of the last points I want to make about the cell phone ban, is the school policy may allow exceptions on this prohibition at the discretion of the district or school. The district can allow the definition of school time to exclude lunch and passing periods only in the high school context. So if your policy allows it, high school students can be allowed to use those wireless communication devices during lunch and during their passing periods. If school personnel have authorized the student to use a device for educational purposes, then the policy can allow for that. The policy can also allow an exception in the event of an emergency, as long as that possibility is detailed in at least one of the school districts or schools' emergency and crisis response plans, protocols, or procedures. And finally, the bill talks about the prohibition on enforcing a school or district cell phone policy through fees, fines, suspensions, expulsions, or deployment of your SRO or local law enforcement, unless the phone or device is used to engage in other gross disobedience or misconduct. So, for example, we can't, it can't result in an out of school suspension if a student is just using their phone during the school day. But if, for example, they're engaged in sexting during the school day that, might constitute Title IX sexual harassment, and we go through that process and determine that the student did engage in that, then we could discipline for those purposes, for example, because it was used in another form of misconduct. This bill also revises section 10-22(6) of the school code, which talks about suspensions and expulsions of students. And it explicitly states that out of school suspensions and expulsions cannot be used for violations of this policy. The policy has to be published in your student handbook and on the school district's website. The policy also has to be provided annually to parents, guardians, and school personnel, including new employees and substitute teachers when they're hired. The development of the policy has to include input from the teachers union representatives, administrators, and parents or guardians. It also encourages student input. And then that policy needs to be reviewed every 3 years. Before I turn it back over to Jared, I did see a question here about whether there's still kind of a bell-to-bell policy with restriction, bell-to-bell restriction including hallways and lunchrooms. Yes, that is the case unless your policy explicitly says that students in high school can use it in the lunchroom or during passing periods. The last thing I want to note about this wireless device policy is this bill does allow for, if you currently have a policy in place that restricts wireless device usage at school, you can keep that in place until 2030, and then you have to update your policy to make sure it aligns with the requirements of this bill. I also saw a question about presentation materials. Yes, those presentation materials from today can and will be made available. All right, and now with that, I'm going to turn it back over to Jared to talk about our bills related to health, safety, and facilities.
Hey, thank you, Emily. The first one is House Bill 5107, Alyssa's Law. Alyssa's Law was passed by both the House and the Senate. It provides that by March 1st, 2027, the Illinois State Police is to develop rules for a mobile panic alert system to qualify as an Alyssa's alert and to meet the requirements outlined in the bill. Um, those rules will be posted on the Illinois State Police and the Illinois State Board of Education's website. Um, it also provides that no later than the beginning of the 2028-2029 school year, school districts and private schools are to consider the use of a mobile panic alert system and the development of their school emergency and crisis response plans. If used, the mobile panic alert system that meets the requirements of the new law will be known as an Alyssa's alert and would be capable of connecting to emergency service technologies that will provide real-time coordination between multiple first responder agencies. It also requires that each school district or private school to coordinate with its local 911 authority for integration requirements prior to purchasing and implementing that alert system. The next one is Senate Bill 3051, an undesignated glucagon. Um, the act defines undesignated glucagon as glucagon rescue therapy approved by the FDA and prescribed in the name of a school district, public school, charter school, or non-public school for the treatment of severe hypoglycemia in a dosage form that could be rapidly administered to a person in an emergency, including pre-filled or nasally administered glucagon. It allows nurses or trained personnel to provide the undesignated glucagon to personnel authorized under an individual healthcare action plan in accordance with a 504 plan, an IEP, or other accommodation plan to administer the glucagon or undesignated glucagon to a student. There are notification requirements. It requires notification to a parent or guardian, and if known, the physician, physician's assistant, or the RN providing prescription for the glucagon within 24 hours of administration of that medication. It requires a report to the Illinois State Board of Education as well, within 3 days after administration of the undesignated glucagon. It also requires trained personnel to complete training annually before they are able to administer the undesignated glucagon. And there are certain training requirements as well that are outlined in the law. The next piece of legislation is House Bill 4379, Adult Changing Station. Um, the legislation was passed by both the House and the Senate, and it establishes adult changing requirements in certain public buildings. Now, an adult changing station is defined by the statute as a wheelchair accessible toilet facility that is compliant with the ADA and ADA regulations, or a private enclosed family or assisted use toilet facility, both of which are required to meet the new requirements outlined in the bill. The new requirements, will go into some of them, relate to maneuvering, clearance, signage, equipment, and plumbing in the room. The bill also provides additional requirements for buildings built after January 1st, 2029, those requirements do include installing at least one adult changing station in the building, maintaining, repairing, and replacing changing tables as necessary. It does require that the changing station be cleaned with the same frequency as other restrooms are cleaned in the building, and there must be sufficient space to comply with the ADA. Note that the entrance to the restroom that contains the adult changing station must also have conspicuous signage. And if there's a central directory for the building must have an indication in the directory of the location of adult changing stations. And lastly, there must be a building structure designated to serve as a public building. This is typically if we see a campus with more than one building, this would apply to the building that's designated as the public building. I'm going to hand it back over to Emily to discuss public acts that are in effect this summer.
Awesome. Thank you, Jared. I know we're kind of at the end of our time here. There's only 3 public acts that I want to talk about and just issue a reminder here that those either have gone into effect or are about to go into effect this summer. So these are on your radar. The first is Public Act 104259, which relates to NICU leave. So starting the beginning of this month, June 1st, 2026, it requires employers to provide employees with up to 20 days of unpaid leave while their child is in the NICU. This is true for employers with over 50 employees, which I assume is many of you. If you have between 16 and 50 employees, then only 10 days of leave are required. That leave may be continual or intermittent, and employers can still require verification of the child's NICU stay in order to grant leave under this policy. The next one is cyberbullying. So this is effective as of the 1st of July, so coming up here. And it states that beginning with the 26-27 school year, cyberbullying has to include, the definition, I'm sorry, of cyberbullying has to include the posting or distribution of an unauthorized digital replica by electronic means. It defines unauthorized digital replica as the digital replica of an individual without the consent of the depicted individual. And the digital replica is defined itself to mean electronic representation of an individual using technology, artificial intelligence that appears to be so realistic that a reasonable person would believe it to be the actual individual. So really what this means is we have to include in our definition of cyberbullying kind of unauthorized or non-consensual AI images of, a bullying or sexual nature. I know a lot of folks have been seeing this issue pop up in their school buildings. And so I think this is really an attempt by the legislature to address that. And then lastly, we have Public Act 104393 regarding emergency contract renewals. This is effective also on July 1st of 2026. It provides changes to how school boards should enter into contracts with non-instructional service providers. It defines an emergency situation. It also provides that the board has to post all vacant positions for any renewed emergency contract for the entirety of the emergency. And it requires additional requirements for emergency contract renewals with non-instructional service providers that increase the workforce by 2 or 3 times and requires mutual agreement with the affected bargaining unit if those contract renewals increase the workforce by 2 or 3 times. So those are things to keep on your radar as they're going into effect within the next week or 2 here. I know we answered questions along the way. It doesn't look like any more are pending. We will be posting, as I said, the full recording of this presentation as well as the materials so that you can review those. And of course, if you have any additional questions about any of the new legislation, please feel free to contact any member of our firm and we're happy to assist further.